Good afternoon, everyone. Thank you for attending today's seminar on legal professional privilege. My name is Hasti Kalarastagi. I'm one of the managing partners at Hunt & Hunt in New South Wales. I'm also the lead environment planning partner in New South Wales. Today I have with me a colleague and friend of mine, Priyan Afshar, who's a barrister at 9 Wentworth Chambers. Priyan has very kindly agreed to come and do this presentation. And as always, I have learned in my 21 plus years career that you never need to upstage a barrister. So Priyan will do the heavy lifting and I will do the other things. Just by way of introduction, Priyan is a barrister with 12 years experience in commercial litigation, equity insolvency and corporations. His practice focuses on complex commercial disputes, and he has also appeared in a number of high profile matters, including high profile defamation matters and professional negligence matters. Priyan regularly appears unled in the Supreme Court, federal courts, and said he's got a matter in the High Court next week. And he also appears led in matters. We are doing a hybrid presentation, so we have a number of people present in this room. Obviously, we have a number of attendees joining us online. If I could just ask as a matter of housekeeping, if those who are appearing online can go on mute so that we don't have any background. Also, the presentation is being recorded. So anyone who needs a copy of the presentation, we will provide you with a copy afterwards. I just need to get the clicker. Make sure it works. And as I said, I'm a bit rusty using the clicker, so let's see how we go. So we are presenting on the recent updates on legal professional privilege. It is a hot topic. It is always a hot topic. We've broken it down into a series of topics. We'll be looking at essentially different types of privilege that is available to claim, whether it's client legal privilege. Is it a client legal privilege? Is it professional privilege? Why do we call it client privilege? But we'll look at public interest immunity, common interest principles, looking at some without prejudice documents and what does that actually mean? Can you claim prejudice? Can you waive your prejudice? How does that work? We will also then be looking at some other elements of waiver, which is really important. We'll look at some recent cases, one not so recent case, but that is a good lessons to be learned. And we'll take on some questions as we go. So if I can just pass on over to Priyan, and we want to start talking about privileges.
I'll start with privileges. I was going to say to Hasti that one of the problems with giving the floor to a barrister is that the thing never ends because we like to keep talking and talking, but I will try to keep it brief and I'll try to keep it to topic. One of the things that I always sort of start with when I do a presentation on legal professional privilege is to set the scene as to what privilege actually is, because I think oftentimes we're not taught from that starting point. We're taught a number of sections of the Evidence Act and a bunch of stuff about how privilege may be waived. But privilege is, as the word suggests, actually a privilege to have a relationship, or it describes a relationship that stands apart from other relationships where communications as between the people in that relationship cannot be produced at court, and obviously has a particular policy basis, which all of you are aware of, which is being honest with your own lawyers in effect and telling them even things that may be harmful to your case. The other aspect of it is, of course, that it's actually really discretionary. It's never absolute. So there are obviously rules that impose that privilege or stop a communication from being divulged in court. But really, it's a balancing exercise. And that goes for all of these different types of privilege, because in each of them, there are circumstances where a court might say, well, actually, that's very interesting. Yes, you have satisfied all of the requirements of this document being privileged, but for certain reasons, I'm going to still allow for that document to be led in evidence in court. And that goes for without prejudice privilege, public interest immunity, which is actually a very classic sort of balancing exercise, and of course, legal professional privilege. So that, I think, is a sort of starting point, the framework for the discussion that I thought we would have today. And please, if you have any questions, please just put your hands up and we can discuss it as we go. But the way that we propose to deal with it was to talk about how privilege comes into being and how it's waived. Really, those are the two aspects, with a special focus on how these challenges, I suppose, in terms of both the claiming of privilege and also its waiver arise in in-house circumstances, because in-house, the position of a lawyer in-house actually creates certain challenges that other people, for example, barristers, don't have. What is given to me is privileged. It's the client's privilege. Obviously, I don't get to waive it. And if I waive it, it's either strategic, hopefully it's not implied, or through accident. Whereas and I have one particular purpose, to give advice and engage in litigation and to run the litigation. Whereas for in-house roles, and I should say similarly, people in private practice have a particular function, which is to provide advice, or if they're litigants, to run the litigation alongside providing advice. Whereas the position of the in-house lawyer is very different. You have a business function as in addition to your legal function, and drawing a fine line between those functions allows you to navigate some of these rules and ensure that the communications that are supposed to be privileged remain privileged. So that's where we're starting. So let me just give you a brief introduction to the different types of privileges. Legal professional privilege, obviously centered to most of the things that we do. Broadly speaking, that splits out into two different types of privilege. There's advice privilege and litigation privilege. We'll dive into that in a bit more detail. Public interest immunity.
Can I ask a question?
Yes, of course.
Why is a client legal privilege?
Good question. Look, it's client legal privilege because it arises from the client-lawyer relationship, and it belongs to the client. Those are the two reasons why it's client legal privilege. Lawyers don't get to waive the client's privilege, and the client is the only person who can give, through giving him instructions, the imprimatur for that privilege to be waived. It arises from a relationship. We'll get into what are the aspects of that relationship, but really there has to be some form of a retainer. Now that retainer doesn't necessarily have to be in writing. It can be oral, it can be through conduct, but there needs to be that relationship for there to be privilege to begin with. When we get to public interest immunity is a disclosure, bar the disclosure of certain materials where the balancing act between disclosure or the right to disclosure or the need for disclosure, the benefits of disclosure, are weighed against the public interest in them not being disclosed, or not disclosure not taking place. I won't spend too much time on public interest immunity because we're talking about the broader subject matter of privilege, but again, it's a balancing act, much like privilege generally. Common interest privilege is a subset of legal professional privilege as between parties with the same interest. And that usually happens where you have, at a general level, that's what happens when you have multiple parties to litigation, for example, but they are closely connected and have the same interest, they can share documents as between them. Just because one party decided to share documents with another party doesn't waive privilege. Confidentiality is maintained as between the parties. And then finally, without prejudice privilege, we won't spend too much time on that either, but can I just make a couple of points about this? There's a fair bit of confusion generally in the way practice operates in terms of what is actually covered by without prejudice privilege. Can I say two things? Just because it's without prejudice service to costs at the top of the letter doesn't of course mean that that document and the contents of it are subject to the without prejudice privilege. The core point is that if there is a proposal for a deal, for some sort of negotiation, some sort of an offer, some comment on an offer, but it needs to be connected to the offer that is made in the letter, then that starts becoming something over which without prejudice privilege may be claimed. If it is simply a list of all the reasons why the other side's case is horrendous and awful and ludicrous and it must fail, and it ends with your case will fail and that's it, or we reserve our rights or something like that, then it's not really an offer. It does really depend on the contents of that communication, whether or not you can claim the privilege. The second thing is that one party cannot unilaterally waive without prejudice privilege. It's actually a privilege that binds both parties. So one has to be really careful in preparing evidence. I find it quite regular, unfortunately quite regular, where you open up people's exhibits and there's a whole lot of without prejudice communication, so they're just put in there. Of course, we'll take objection, and generally if you have a sensible opponent, that doesn't ever get to the judge, but there is a tendency to do that, and there may be a bit of a thought amongst some members of the profession that you can just waive it by just putting it into evidence. That doesn't happen. Both sides need to waive it. So what are the elements of legal professional privilege? Again, that's the focus. This is a list, and I just want to go through it, and I want you to have a think about this, especially for in-house counsel, where you are preparing documents, so you're being asked to prepare the documents. These are the elements that you need to have in mind in order to draw that fine line that I was speaking about before, to distinguish between what is the legal function of the position of in-house counsel and what's the business function of the position of in-house counsel. And that doesn't matter whether you're in-house counsel within actually a corporate entity or a business or a government entity. It's the same principles. And they are the retainer. Now, in-house counsel don't have that problem. They already have that relationship between them and the client as such, which is the business or the entity. But for us, I need to have my cost agreement, of course, with my solicitors. Solicitors have to have their cost agreement or retainer with their clients. And that's what establishes the base for the legal professional privilege. Confidentiality, this is where usually there's a question as to what type of confidentiality regime will protect privilege. Again, with me and my instructing solicitors, that usually is pretty well understood. I'm supposed to keep whatever I receive from them confidential and vice versa. As between private practice and clients, that again is probably understood because the solicitor will need to keep that confidential. Within clients, there's a bit of a question. I think there was a question raised about to the extent to which, I'm not sure who raised it, but the extent to which a contractor who has an agreement with a business and in his or her contract there's a confidentiality clause, to what extent does that confidentiality clause protect privileged communications? And we've got to be very careful about that. I think the example that we had wasn't, I don't think we can put it up there, but that's okay. It wasn't actually on all fours with maintaining privilege over communications that are otherwise privileged from lawyers. So I think that if you ever want to give the contents of advice that you receive from counsel or otherwise to a contractor, it's really important to not just rely on the confidentiality provisions in their contracts. That might not be adequate. It's probably best to have a standard form that you get advice on and get drafted specifically for this purpose in order to maintain privilege. You should, sorry.
I've got one more question on that,
Yes.
question. What happens in terms of if the contractor has access to, say, personal information of people? So in the day-to-day performance of the contract, they also combine and collect some personal information that relates to the people that they've encountered in performance of the contract of that agreement. And they're obviously intended to keep that information confidential. And I know there's obviously other legislation that governs this area. But does it fall under privilege, or is that the same thing as, it is just confidential, governed by other legislation, but privilege is not attached to that information?
Well, insofar as that information is privileged, again, it just really depends on the extent of the confidentiality term. If it's not privileged, obviously, then you go down the path of being protected by privacy legislation, or generally under the confidentiality term, equity imposing confidentiality indicia on top of that information to protect it.
So the solution in both scenarios would be to have a one-pager agreement or retainer or some document, we call it whatever you want, that says the information is provided to you and gathered by you is privileged.
Yeah, I mean, generally, I would avoid giving you the information to begin with to a contractor. If you really have to give it to a contractor, then I think you need to build that relationship, the basis of it, so that you don't suddenly fall outside a relationship where privilege can be imputed. So I'd probably avoid it, but if you do need to do it, you need to have some standard terms that go beyond potentially the confidentiality terms that apply to that party's contract. I suppose that perhaps if I could put it this way, and I know it's probably bad for this subject matter, but the sexiest part of the definition of privilege is actually, and where the most fighting happens, is about the dominant purpose of the document. So the question really becomes, well, why did you create these documents? That's what the court's going to ask. And if you created the document for the dominant purpose of giving or receiving legal advice, that's where you're falling within the definitions in the Evidence Act. And for anyone who practices in common law jurisdictions where they don't have the Evidence Act, the same rule applies. Although the common law rule, I think, is a bit narrower than the statutory rule. But the fundamental point is that if the overriding purpose, in effect, is the provision or receipt of the legal advice, then the document is caught. Sometimes, in fact, most of the time, that sort of goes without saying. You look at the document and you think, well, that's a letter of advice or an email from counsel sending something about the strength and weaknesses of a case. Of course, that's advice. Of course, we just carry on with that. But in relation to edge cases, the court will look at who the recipients are and who the senders are, what happened beforehand that caused that document to be sent. There might be need for evidence to be, in fact, read, and people need to be cross-examined on some occasions. And really, it becomes a case within a case about the circumstances, the creation of the document. This is really, really important. This dominant purpose point is really important for in-house. So let me just give you an example. Someone comes along and says to you, look, I've got a report that I have created internally, some sort of investigation that happens within government departments or by government departments at all times. They just send you that email, send you that report attached to an email. Does that report become privileged because of the communication or because of the fact that it was sent to a lawyer? Probably not in and of itself. That's not enough to make that document privileged or stopping it being disclosed in a court. What needs to happen next is what is, I think, really important. If it was a draft report and it was sent to a lawyer to give advice on its contents and to see whether or not, as a draft report, it complies with either regulations or legislation or something else, well, then you're sort of getting closer to a document that's been provided to the lawyer for the dominant purpose of giving advice. If it was a letter that was going to be sent out into the public, but first the lawyer needed to settle it or provide comments on it, well, again, we're now into a lot closer to the idea of the purpose being satisfied. Now, in in-house work, at least from my experience of seeing it from the outside, I have never been on in-house counsel, but I have been a solicitor for a number of years, and I've obviously been a barrister for a while. That line is not always clear. But can I just give you some ideas around how you can maintain privilege and keep the line as clear as you can? One thing is to avoid email chains. I know it's easy to say, but generally what happens is emails hurtle around an organization and then end up 15th, 20th chain, end up with you as the in-house counsel. To respond to that doesn't make everything in that chain privileged. And it might, in fact, be the fact that you're responding in a chain might be a reason why privilege is waived, or it is not captured, or doesn't meet the relevant criteria of becoming privileged. So it's actually really important when people send emails to always, if they actually are seeking advice, you might want to actually ask them to resend it to you in a clear email where they say, I want legal advice about this, or can you look at this and give me advice about it? And then you respond to that as opposed to just respond to a big chain of materials. The other reason why email chains are a real killer when it comes to these types of disclosures is that it provides a path by the person seeking disclosure to find your email, because email chains might have different branches. If they get hold of one of those branches or one of those emails, they can work backwards to find the original source, and then they get you by seeking, you know, production by way of notice to produce or a subpoena of the entirety of the chain, and you might get a number of different branches. One of it would be something that has come to you. And in terms of advice and litigation privilege, really the difference is that the advice that falls within litigation privilege would be connected to litigation. That's obviously foreshadowed litigation or litigation that is ongoing. That's the touchstone by which one can see whether or not it falls within Section 118 of the Evidence Act, which is your standard legal professional privilege of advice privilege, and 119, which is the litigation privilege. With, if I just go back, sorry. Yes, so we've spoken a bit about in-house challenges. I'll give you some more examples as we go. We want to talk about waiver in terms of, we'll come to it in a bit more detail a bit later on, but there are two types of waiver. So once you have your privilege established, if you establish it, then the question becomes, the fight becomes whether it has been waived. Two types of waiver: either you waive it intentionally and expressly. So when I tender my instructing solicitor's advice to the client for a forensic purpose, I make that decision. I've already got instructions. I'm making that expressly. And once that document is in, all privilege in relation to it has been waived. But most of the time, what happens is that there is some form of implied waiver. Now that ranges from an accident, which is not being rectified, happens all the time with discovery, especially large-scale discovery where hundreds of thousands of documents have been produced, to where people make forensic decisions where the maintenance of the privilege becomes a question mark. Putting it another way, they make forensic decisions that make the maintenance of the privilege something that the court would not countenance, would not allow. And I just want to give you by way of an example, basically on both sides of the line in terms of implied privilege, implied waiver. If one says, I have advice from my solicitors, that doesn't waive privilege generally in and of itself. If there is a context around the conversation that is taking place, why did you say that? In what context did you say that? That may begin to move towards the waiver of privilege. If you say, I got advice and you're going to lose the case, well, then again, you're coming closer to the question of whether or not it has been waived. You probably still haven't waived it, probably, but you're getting very close to the edge. If you put out a public announcement, as this has happened from time to time with a number of organisations that do a lot of public announcements like ASIC and others, and the ATO, if you start referring to the substance of the advice, then the authorities are, well, at that point in time, you'll probably have implicitly waived that privilege. And the difficulty with this is that we do a lot of communications on a day-to-day basis and engage in it all the time. And we don't necessarily think about it by reference to waiver. But this again goes to anything you do, especially in-house, think about it. You need to establish privilege, so that fine line needs to be maintained in your communications out. But you also need to be able to maintain the privilege. That maintenance of privilege is difficult for in-house counsel because once your advice leaves you and goes to somebody else, it's very difficult to police it and see where it goes from there. My suggestion is to ensure that members of your team, obviously the legal team and then the business team, are well trained on at least how to basically maintain privilege, that is not send documents out, for example, to outside parties. But also to have some processes set up that actually clearly set out who should receive this document, in what circumstances and what levels. Because generally speaking, I would have thought for most of you, the advice isn't just heard around everywhere. It goes to certain decision makers for a certain purpose. And I think having that set out is actually very, very important if later on you need to prove that you never intended for a document to be waived implicitly. I'll just give you an example. The document goes to some sort of C-level executive position. Someone else gets it, sees it, and it's disclosed to a third party without anyone actually approving that disclosure. Well, if you're in a fight at that point in time about implied waiver, you can potentially tender your policy around the disclosure of legal documents and who should have access to it and who shouldn't have access to it, to say this was either an accident or something that was unauthorized. Now, that document would actually be very helpful in any fight like that. There are a couple of other ways that, sorry, I'll get there.
I'm controlling you back to talk about having to control.
There are other ways that privilege may be lost. Section 125 of the Evidence Act is a good example of that. If there's misconduct in that, for example, unlawful conduct is being communicated through a communication that otherwise would be privileged, but that it is actually in the commission of an offence or some sort of unlawful conduct, courts might come along and say, no, there's no privilege, you can actually tender that in evidence. We have spoken about a number of these, so I won't go over them again. I think that we all would have likely have the confidentiality notice on our emails, especially. If you don't have it, I suggest you include that, just so that, again, if it's a wayward email, for some reason it gets to somebody else, you have something to say later on if there's going to be a fight about it. Let me just focus on the last three arrows. The first is a disciplined approach to in-house communication. We've spoken about that a bit. My suggestion is, if you organize and manage your team to make sure that those types of rules about new emails, new documents, as opposed to following chains, are maintained, you have basically taken away probably 70–80% of the risk that privilege would be waived within your organization, just inadvertently. And then the next stage is, of course, the training that you provide other people outside the legal team. That's also quite important. And then when it comes to maintaining privilege, you're again harking back to those elements that we talked about. Again, you got your legal relationship because you're acting for the client or inside the client. Is it confidential? What's the dominant purpose of it? And does that mean that that document is privileged? If there's going to be a waiver conversation, it's about those matters. It usually gets documents, implicit waiver really applies to where confidentiality is also waived or breached. The last point is legal advice versus compliance versus policy. This is a substantive matter, and it goes to really a question of judgment, and it really depends on the contents of the communication. It's really important that you focus on the contents of the communication to ensure that legal advice is not disclosed in the form of a policy. It's a line between a policy that tells people, provides guidelines, and then a document that might be explanatory of that policy that goes into how that policy should be interpreted, which may be legal advice. Or in terms of government, a regulation that is then implemented internally through a policy is on one side of the equation, whereas on the other might be your advice about how that should be implemented or how it should be interpreted. That is advice. Because of there are no bright lines, even though you try to chart a path through and draw a bright line, generally you are dealing with grey areas. And these types of documents, you've got your compliance documents, you've got your policy documents, and you've got your legal advice. Sometimes they sort of overlap. So to the extent possible, you want to take that overlap out and you want to reduce the extent of it. in order to maintain your privilege. Speak up.
Sir?
Yes.
Could I please ask a question before you move on?
Yes, of course.
In the example that you gave about reviewing a report and giving any legal input, sometimes the reports are like 100 pages. If you wanted to be like extra careful, would it be better to note any issues in the body of an email rather than throughout the report? When you just when you were saying that sometimes legal versus policy documents, there's it gets a little bit blurred, and you might be looking at more of a policy document, but you're actually giving legal advice. Is there any benefit in saying, okay, it's better to make my observations in a different type of document as opposed to commenting throughout the report?
Absolutely.
Okay.
That's my, it's also, that's usually my approach with, say, expert reports. I know it's a different type of report that you're thinking about. So an internal report where you have to provide some sort of advice in relation to it, I suggest probably doing the advice separately, because there will be a fight as to whether, I mean, and I'm just working it through, wargaming it out of it. You provide your advice inside the document. I'm the opponent. I issue a notice to produce. You have to produce that report. Now, just pausing there, you can't resist the production of the report by claiming privilege. Privilege is not an answer to production. Privilege is only access, an answer to access. So then there's going to be a fight about whether or not this document is privileged. You have a document that goes for hundreds of pages. You've potentially commented on 1 page or 2 pages within the body. Now, the other comments are also there from other people who are not lawyers. In those circumstances, judges might be a bit reluctant just to redact one part of it and give access to the balance. It just waters down your claim for privilege when there are all this other material that may be relevant to the facts in issue that are captured by the document that I've now sought disclosure of. So, but if you had done this separately, then the claim for privilege is much stronger, because that email is just about your legal advice. And then it'd be very difficult for me to say, well, I want to see the report and I want the legal advice. Of course, unless the legal advice itself is an issue, and that's a different issue altogether. So it's all, as I said, it's a discretion. You see, it's all weighing up the practical operation of the legal system against the protecting your privilege. So if it turns out that hundreds of pages of other materials might be relevant, and the court might say in those circumstances, well, redact this page. But sometimes, because you might be referring to different parts of it, people might be referring to your comments, it then starts losing the privilege quality.
We've also picked out 2 cases to demonstrate how privilege works in a practical sense. The first case is Secretary, Department of Planning and Environment against and Clindy, Edenmore, O'Brien, and O'Brien. It's a series of Class 5 proceedings that are running together, and it's a recent decision of Justice Pritchard in Class 5 jurisdiction of the Land and Environment Court. So it's a criminal offence jurisdiction of the Land and Environment Court. And the second case is the Sani Properties and the State of New South Wales, which is a 2018 decision of Justice Rob in the Equity, where he essentially had to determine the issue of privilege that was being claimed as part of the overall Sani litigation. For those, I think most people in this room and who are on the call know this, Dasani is very close to my heart, because I was actually cross-examined by Dasani's senior counsel in order to be able to, for them to demonstrate that privilege did not exist, and the fact that our RMS, as it was then, was claiming legal professional privilege over a series of documents, and they were trying to essentially say that the way we had claimed our privilege was incorrect. So they're both quite on point. In relation to the Justice Pritchard decision of, I'm just going to call it Secretary Department of Planning decision, and I don't know if you have anyone online who was party to these, so apologies if I get any of the facts wrong. The substantive proceedings related to, as I said, I think it's 8 concurrent proceedings where the Secretary of the Department of Planning and Environment, known as the prosecutor, had issued 12 summons on the defendants for illegal clearing of native vegetation on 2 adjoining properties. The properties were the both Clindy Farm and Edenmore Farm, and they're both at Pilgai in New South Wales. The summons was issued for clearing that was done during the period of 13 February 2020 through to 13 March 2020 and 13 March 2020 through to 23rd March 2020. That particular proceeding was also commenced by the prosecutor on 17 June 2022. Now, the reason why those dates are important is because the prosecutor had initially commenced an earlier proceedings for some earlier clearing of native vegetation against the same defendants. The timing for those alleged offences was between 31st of August of 2017 through to 30th of September 2018. And that earlier proceedings had commenced in March 2021. And then the prosecutor withdrew that proceeding in July 2022 and just proceeded with the proceeding that were commenced in June 2022. So many numbers, so many dates. Hang in with me. As happened during these proceedings, the defendant issued a subpoena to the prosecutor. The first version of the subpoena that was issued was an unfiled subpoena emailed to the prosecutor, and it also had the details of the parties, the defendants wrong. So the prosecutor told the defendants to fix it and also make sure that you file it and serve it on us. So then the defendants then essentially read the subpoena and issued a second, or as it's known in judgment, the first subpoena. The subpoena consisted of 14 paragraphs describing documents, a number of documents to be produced. 9 of those 14 paragraphs related to documents that were created in the period of 1st of January 2012 to 23 June 2022. So those documents that the defendants were trying to capture under those relevant paragraphs in the subpoena had to do with the earlier proceedings and not the proceedings that had remained on foot. So there was some communication between the parties, and obviously the defendants said the reason why they were pressing for those early documents is because they wanted to know what investigation had taken place for the earlier offences and what was in the mind of the investigators and the prosecutor in relation to those earlier offences, because it related to the current offences that they were being prosecuted for. Again, in news that would not surprise anyone, the prosecutor put out a notice of motion to set aside a number of paragraphs. The parties, as happens during litigation, negotiated the scope of the subpoena. Some amended terms were put forward, some amended scopes were put on, and the matter was, the notice of motion was heard by Justice Duggan. And given that the parties had agreed to an amended scope and an amended subpoena in relation to some of the documents, particularly the earlier documents that was being sought, Harold didn't actually rule on the notice of motion. The prosecutor then produced a series of documents in tranches. And the final tranche of documents that was produced on 13th of February 2023 contained 248 documents where the prosecutor then claimed legal privilege over it. As part of the claiming of the legal privilege, what you have to do is you have to identify the document that you have produced, the date, and the reason why you're claiming legal privilege. An index was given by the prosecutor, and the solicitor acting for the prosecutor was an in-house solicitor. The matter was then heard before Justice Payne because the defendant objected to the claim for legal privilege. And Justice Payne directed the prosecutor to put on an affidavit explaining the basis of the claim for privilege. So then the prosecutor put on an affidavit, put on an amended index, and as part of that amended index, they dropped the claim for up from 248 documents to 217 documents. Sorry, 216 documents. The updated index then also included information in terms of what the correspondence, who the correspondence were between, the date of the correspondence, a very brief description of the correspondence, and if anyone was blind copied, and the purpose of which they had been and privilege had been claimed. As part of the PowerPoint presentation, which everyone will get, we've put in the section 117 definition of what is what client means, what is confidential communication, what is a confidential document, what is a lawyer, but also the two grounds that you can claim legal privilege. Under section 118, you can claim legal privilege over legal advice, or 119, you can claim legal privilege for material that has been created in anticipation of litigation happening. So as Puyan had said, one of the very many things that the court had to deal with and Justice Pritchard had to deal with were chains of emails that had been created. And whether or not those chains of email attracted privilege. So then the court exercised its discretion on section 133 of the Evidence Act to actually review the documents in chambers. And so Her Honor looks through those documents in chambers. Her Honor essentially goes through the process, in the judgment, she goes through the process of establishing the privilege, and which is a two-stage process. The first stage is there privilege? Is it under 118? You were giving legal advice, that's your dominant purpose, or were you providing legal advice in anticipation of litigation? And then if your document falls within either of those two premises, then would the production of that document result in disclosure of confidential information? And whether or not you can have partial disclosure. So for instance, producing redacted documents, can you do that in order to have in order to partially produce, but also protect the confidential information? And it was also agreed by everyone that the onus to providing and producing a claim for privilege is on the person or the party that is claiming privilege. So Her Honor went through the documents, and the prosecutor had essentially advised the Honor in a further affidavit that there were three broad categories in which the prosecutor was claiming privilege. The first category were documents that were created between January and August 2020, at the time when the defendants were being investigated for the earlier proceedings. And that the description in these documents were essentially documents that were created for purpose of providing legal advice under section 118. And there were email chain discussions between the prosecutor's investigative arm and the compliance officers. And then there were certain documents that were created for the purpose under section 119 for the purpose of anticipating litigation. The second tranche of documents, or the second category of documents that privilege were being claimed over, were documents that were created between January and June 2021. And these were essentially, again, majority of which were email correspondence, chains of email correspondence between the investigation officer, the compliance officer, and one lawyer within legal branch at the prosecutors, discussing legal advice. Certain documents were provided, some certain advice were done, and things were done in anticipation of litigation. So privilege was being claimed under section 118 and section 119. And then the third category in which there were documents were being claimed privilege were two specific documents that had been created that fell, according to the prosecutor, fell under section 118. And those documents were a logbook and an exhibit of a logbook that had been provided to the prosecutor. Her Honor looked through it, and Her Honor did also make a comment that as she was reviewing the email chains, that it would have been much better use of her time, my words, not hers, that if the prosecutor had in fact gone through the email chain and had identified the emails in which they wanted to claim privilege over, as opposed to dump the entirety of the email chains on Her Honor for her inspection. Again, my words, not her words, but that was essentially what she had said was, it was just not a good use of her time having to review their email chains. Having reviewed those documents, Her Honor found that in terms of the first category of documents, which were the email correspondence between the compliance and investigation officers, majority of those emails did not attract privilege under section 118 because there was no lawyers copied into it. There was no nature of anyone asking for legal advice. It was just an investigation. There was a couple of emails where then they had included the lawyer from the legal branch. So therefore, Her Honor found those particular chains, those emails alone themselves attracted privilege, but not the chain of email that went with those emails. In terms of some other subsequent communication that fell under category 1, that was in fact done, very clearly said, we are seeking your advice. Her Honor applied privilege under section 119. In terms of the documents that form part of the second category of document, which was a correspondence that were created between January 2021 and June 2021, that related to both the earlier proceedings and the current proceedings that are on foot, Her Honour found that the majority of the email correspondence and the documents that were created that fell within that category met the test in both section 118 and section 119, because in all of those communication, a lawyer had been copied in. And also the content of the email, the correspondence, I'm assuming they're all emails, was of a nature that the author was asking for advice. So therefore, the dominant purpose was very clear that this was all done for the purpose of providing legal advice or in anticipation of commencing proceedings. The third category, which was correspondence on 10 June 2022, which had essentially two documents. One was an exhibit log and one was an exhibit book. So a field exhibit log and an exhibit book. That was from a departmental investigator that was then given to the department lawyer. Her Honour found that there was no privilege attached to the logbook or that exhibit book, and that there was nothing in the provision of that, in that report essentially to the lawyer that said, here you go, this is, in anticipation of a legal advice or preparation for a hearing. So that privilege was not claimed. What are the lessons to be learned from here? And it's also the similar lessons that we should really learn from Dasani, is that when it comes to creating email chains, we really need to be careful about what it is that we are doing and what we are doing. Now, email chains bad. I say this to everybody, email chains are really, really bad. Please don't do them. We all love using reply all, reply forward, all of those things. Please don't. Just create a new email. It's not that hard. In the matter of Dasani Properties Pty Limited and the state of New South Wales, the substantive proceedings were in relation to Dasani trying to claim that a proposed acquisition notice that was issued by the Roads and Maritime Service, the former Roads and Maritime Services, back in 2018 or 2017 at that point, was in fact invalid, and that RMS could not exercise its functions to compulsory acquire Dasani's property for the purpose of the Roselle interchange. And there were three elements to the claim. First one was that there was no public purpose, and the public purpose wasn't clearly articulated, so therefore Dasani couldn't identify what the public purpose was. The second element to that case was that RMS hadn't had enough time to sufficiently finalize its investigation of the project, and therefore it wasn't very clear that the land was required for the purposes that was being acquired. So therefore, RMS couldn't validly form the view to acquire this land. And the third element to the case had to do with a misleading and deceptive conduct. That the fact that RMS had said there's public purpose, there's more than one public purpose, was essentially misleading and deceptive, and that wasn't. And under that element, they had brought in not only a state of New South Wales, but also the Sydney Motorway Corporations. So that was the substantive proceedings. As part of the substantive proceedings, this orders for discovery was issued by Hammerschlag, and the parties agreed to certain categories for discovery. The categories were quite wide. There was a lot of negotiation that went on with what those categories would be. And significant and keywords were essentially given. So we undertook a major scale discovery of material within not only RMS, but a number of agencies for documents that related to certain keywords that were captured in categories. As part of the mass discovery that we did, we reviewed 49,000 documents. Now, when I say 49,000 documents, they were not individual documents. Each document ranged between, say, a 3-page email to a 10,000-page technical document that related to construction of WestConnex and the interchange. There were a number of production was given of a number of things. Many lists were done. I still sort of have semi-nightmares about how to redact documents on PDF and whether or not I redacted things. And we claimed privilege over a significant amount of documents, waived some of those privilege as it came when we realized we couldn't maintain privilege for some of those things. But essentially, privilege was claimed on the grounds of public interest immunity and client legal privilege. One of my favorite parts of the public interest immunity privilege was we were told we had to maintain privilege over an artist's impression of the Roselle interchange. Hard word by those who said, no way you can release this impression. Must claim privilege over public interest immunity, cannot release this image. Sure, no problem. Put it in our little database, public interest immunity cannot release the image. The image had been released by someone, we don't know who, to the ABC News and had been splashed, not only on the front page of the Sydney Morning Herald, but a number of other organisations. And it had been publicly available for many months before we did the discovery. So yes, inadvertently disclosures happens all the time. Actually, one of my solicitors gave me a copy of that artist impression. It's a Christmas present a couple of years ago. So the other part of it was, obviously then we had our claim for legal professional privilege, which was to do with legal professional privilege. Justice Rob had the pleasure of dealing with the question of privilege over the summer vacation. The matter was set down for hearing in February. His Honour looked through it in January. He was provided with many boxes of folders. His Honour also, as he went to pick up one of the boxes of law and order boxes that contained something like 14 arch lever folders, managed to put his back out. So His Honour was also not very happy about being the judge hearing this matter. Again, the matter was set down for 1 day. The interlocutory hearing, I think, went for 5 days. And as I said, I was cross-examined by the plaintiff because they wanted to establish that privilege had been given. So we provided list and indexes to the documents we had claimed privilege. I had put on a couple of affidavits during the process of the hearing for the privilege. I then put on a couple more affidavits about why we were claiming privilege, establishing, how my instructions came about from the first phone call to who gave me instructions, everyone's role within the department, the reason we had to claim privilege over documents, but not releasing too much information about what the documents were. Dasani's claim was that basically, firstly, the plaintiff tried to say that there was no client legal privilege. And the question was when client legal privilege is. And from my view, it was from the first moment I got my phone call, which would have been like 26th of August, 2016. I was like, all communication is not privileged because of the nature of that phone call. The plaintiff's view was that could not have happened, and that at best the privilege would have kicked in sometime around October 2016, because that is when I had provided an estimate to RMS and had received a Lex ID. And they had gone, I had to produce a copy of the panel deed as part of it so that they could say whether or not certain protocols had been followed through. And essentially what the plaintiff said was that the evidence that I had put on in terms of my affidavit and the evidence on which I was cross-examined was my evidence on when I thought privilege had kicked in. So it was hearsay evidence. It wasn't what was in the mind of those instructing me, and therefore could not be a fact, and therefore privilege could not have kicked in when privilege had kicked in. His Honour Justice Rob found that was not correct, and that despite, protocols having not been met, despite there not being a retainer, any of those type of things, privilege had started from when I was Hunt and Hunt, or I was instructed to act for RMS, because on the minds of both parties, a relationship had commenced, and that His Honour found that there was no need to have a formal retainer in place, where both parties knew that a relationship existed, what the purpose of it was. The second thing the plaintiff tried to do was, there was absolutely no way anyone acting in this matter could have known in 2016 that legal proceedings would commence in 2017. So therefore, when we were claiming privilege at such an early stage, it was too early and premature. Again, His Honour found that based on the evidence that was, again, I was cross-examined on, an affidavit that I had put on, was that in the mind of everyone who was present, including those within RMS who were not legal officers or within the legal branch, but who were property officers who were experienced in acquisition, that if a matter, everything that they were doing would lead to a legal proceeding at some point. If it wasn't these Supreme Court proceedings, it would be a claim for valuation and compensation in the Class 3 jurisdictions of a land environment court. So His Honour found that was fine. One of the things that His Honour struggled with was that the truly difficult question was when the court is required to determine whether privilege applies to a chain of emails. We had many of those, and His Honour looked at those and obviously went through. There was he essentially went through it and looked at it, and his honor found that some of the documents that had been discovered, also the chains of email that had been discovered, were not relevant to the issues that were in dispute within the proceedings. So then his honor ordered that those documents should not be produced, so disclosure wasn't waived on those. There were a series of, I think, 26 emails, where the first 25 emails were discussions about the matter, the issues that were in dispute, and the 26th email, the email on top, was, we are having a meeting at lunch, do you want me to get you a sandwich? And his honor went, okay, well, I will accept that the first 25 emails in that chain attract privilege. The one on top really doesn't. But you know what? It's not relevant, so I'm not going to order disclosure. Again, this is why you should order or always send an email, a fresh email. If you want to get someone lunch, new email. Do you want me to get you lunch? Also, I was not the one who was being lunch was being bought for. It was an internal RMS meeting. So, the other thing that his honor went and looked through was some of the other documents that had been claimed as privilege was a briefing note that had been prepared internally to brief senior counsel, because as everyone within government knows, if you want to brief Silk, you have to get an approval from you have to get approval. And his honor found that that briefing note in itself did not attract privilege. So you couldn't claim privilege over that. But because again, the briefing note was irrelevant in this matter, his honor didn't order disclosure. So ultimately, his honor didn't order disclosure for any of the documents that we had claimed privilege over, whether by way of public interest immunity or client legal privilege. But he then went through and said all that. So it was a good judgment. His honor also considered the concept of the common interest privilege, because some of the documents that Transport RMS had at that point had created, which was essentially a valuation report and a planning report, had been provided to the Office of the Valuer General in the usual process that this information is provided when land is being acquired. And the state of New South Wales had claimed privilege over those because RMS had claimed privilege over those. And his honor found that given that, well, his honor's first finding was those reports then were not relevant in the matter, so therefore he was not going to give disclosure of those documents anyway, which annoyed the plaintiff a lot because they really wanted those reports. And that was the entire reason, the entire purpose of the entire litigation, in my view. They weren't allowed to happen. But also, secondly, his honor found that there was common interest between Roads and Maritime Services and the Valuer General's office and the state of New South Wales in terms of those documents that had come into creation, because they were for the same purpose, which was for the valuing of the land and acquiring it. So there was a common interest that existed there. So his honor, again, withhold those documents. So what does that again teach us? Please start a new email. Email chains are bad. Using the same subject line is bad. Always think about what who your audience is, why you're sending an email, what is the purpose of the email, what do you want? So if you actually are wanting legal advice, then you need to clearly set it out in the email that this is what you want legal advice. And the advice they had given was very good. You know, if as an in-house lawyer, you receive, you know, a chain, like a 25 chain of email going, can you help? It's a really good idea to always go back and clarify, as in, do you need legal advice on this? Do you want me to? What do you want me to do? So clarifying that will help with the dominant purpose issues.
Well, look, I think most of the examples that we were coming to have already been covered by the discussion that we've had, and of course, has these very good examples and the cases. Can I just reiterate that in each of these events, so when you're claiming privilege, when you're in the middle of document production, which is what Hasti's example was, or you're claiming privilege in relation to investigation reports or parts of those reports, or when there's a question of waiver in any of those circumstances, public announcement, discovery, summary of advice, or misconduct, I think really the key takeaways from today, if anything, would be you need to test all those propositions when the document's with you, as opposed to when it gets to me, because that usually is where the horse has well and truly bolted, by reference to those elements of privilege. So has confidentiality been maintained? Is it between me and the client effectively, although that for most in-house, that hurdle's usually satisfied? And then is it for the dominant purpose of providing legal advice? Once you tick those in your head in terms of your analysis, usually you're on firm grounds. But if it is just a comment in a 200-page document, as we just discussed that example before, that not only makes the judge's role very difficult in that they have to wade through all of that to get to your bit, but also it just balances the discretion slightly against finding that there is privilege is maintained. But I think we've basically covered it all.
I'm conscious of the time, but if there's any questions, please ask. Okay, I will now move to that side and try and read out the questions. Sorry, it's in front of me. Okay, first question, how would you recommend managing the sharing of privileged communication on a shared system that, for example, the whole client agency has access to?
Oh, wow. I would avoid having a shared system where everyone has access to all materials. That's basically what I think where we started with in terms of who has access to the documents. I don't know how documents are kept in various departments. I expect that to a large extent, you would have all the protections of the world around your materials that is outside people can't get in. But I expect that there may be some access issues internally. What I suggest is take that access away from people who don't have a need to have that access. Probably the easiest way of looking at it is legal team can have access to all of the legal materials or the materials that form the basis of your advice, previous advices, templates, records of advices, records of meetings, etc. And then you may want to communicate that to others, but again, have that policy. I really do recommend the policy, have an internal policy. It doesn't have to be particularly long, saying legal advice can be provided to department heads, executives, etc. And that's it. And that then be reflected in the training. But if you're intermishing materials and you're really not then, sorry, one step back, you're making it very difficult for yourself to maintain privilege, because your argument should be pretty simple. It's between lawyers, or it's between lawyers and client, and the dominant purpose clearly is X. That's why you don't use email chains, you use separate emails, you direct it to legal advice. That makes your job really easy. The more difficult the argument becomes, the less likely you're going to get to maintain your privilege. And if you're putting all the documents and giving access to everybody, that's a bad start.
I would also recommend locking documents using lock documents. And if something is genuinely privileged, marking it as privileged. One of the very many lessons we have learned over the years is just because a document is marked privileged or cabinet in confidence does not make the document cabinet in confidence or privileged. It really goes to the content of that material. And I know that in many of the agencies, we now have a marking that says secure, confidential. So keep those things, that's the best we can do it.
Another question I have you seen any consideration of from your own mind to privilege detection and communication in a post-COVID world, and specifically really it's the blessing and courtesy of Microsoft Teams and that chat function? What that does is creates an unbroken and undeletable record of correspondence and chats between various people going back several years, which create can you get me lunch?
Yeah.
Two, I've got a quick question because we no longer share a hallway, so I can't ask you questions in the hallway, or it might be, you're in a meeting, a negotiation, or whatever, and you're having side chats there, which reasonably happen to do, but you've got an unbroken chain of everything between going back several years. And unfortunately, it has to an extent become, especially now, a dominant means of correspondence, both out of practicality and sort of necessity. But have you seen anything around sort of treatment of those Teams chats? I mean, because that would effectively give you a wealth of information there.
I'd say not yet, but it's on the rise.
Yeah, I haven't seen any cases about it, but apply the same principles to it. You just take them all as individual emails or individual text messages. I mean, text messages are other thing. I mean, I sometimes communicate with my solicitors through text messages or WhatsApp or whatever. We have sometimes groups where, you know, especially bigger teams of lawyers, we're communicating all within that. Same rules apply. Generally, you want to keep it narrow to 2 people, 3 people who are actually part of that legal discussion. I expect that within house it becomes very difficult because you do have people from all over the business. Yeah, look, it's probably a good idea to market as advice, but then if you have multiple people from multiple tiers, being part of the same chain, the fact that you put advice there might not help you because that advice may be, well, I suppose if it's within the same organization, confidentiality is maintained. But if, for example, you do have a contractor on Microsoft Teams who's day in, day out like anyone else, but he or she's actually a contractor, then you might have a problem there. So that's why you probably want to avoid giving the legal advice on those platforms. You want to keep it to a form that you can control, which is similar to an email. So
Was it arrive on Microsoft Teams and all of those chat options, will pose an issue for the future of standing order number 52s. And you doing a parliamentary inquiry where you have to do the keyword search for those documents because technically they're all discoverable. Fun times. The second question that we had was where you mentioned keeping your comments on a draft report in a standalone advice rather than report itself. Would that also apply, for example, if reviewing a briefing note prepared by a client agency or a draft policy or procedure document? Yes.
yes.
Yeah.
Especially where other people are commenting on it and they're not lawyers. So you then have multiple comments, some of which cannot constitute legal advice or cannot attract privilege. Again, you're just making the job of the judge difficult. And some of them are very conscientious, like Justice Rob, you know, spending hours and hours going through thousands of pages of pieces of paper. Sometimes, depending on where you are, sometimes they'll just say, well, too bad. You haven't persuaded me because there are 100 pages of non-privileged material and it's just a tiny bit, it's waived. Or it's relevant to one another, which is even worse, where people are commenting on comments and replying to comments. I mean, if you, for example, put a piece of advice and someone within the business responded to your comment, because you can do that on Word or PDF or whatever, then the judge might say, well, the privilege is waived because the second comment can't be understood without reference to the first comment. Now, that's a real difficulty.
So I'm going to, up until now, I thought email chains were the worst thing ever. I'm now going to go to
Bubble is
chat,
bad.
comment in a
Bubble
Word
is evil.
document where you put the comments in.
Yes.
That is not evil. That's the first evil, the second evil is email chains. Okay, thank you so much. It's 2:07. Gone a little bit over time, but thank you everyone for attending, participating, asking questions.